name is Justin Myers. I am a Utah bankruptcy attorney. Today we are going to be talking about preferences or payments made to creditors right before the bankruptcy case is filed. This and other topics can be read about in a book I wrote entitled Filing Bankruptcy in Utah. You can order a free copy of this book from the website utahbankruptcybook.com. That's utahbankruptcybook.com. You can also call my office at 801-308-8200, 801-308-8200, and set up a free initial consultation to meet with me. One of the main jobs of a Chapter 7 trustee is to provide for an equality of distribution among the general unsecured creditors. That includes credit cards and medical debts, so that all of these creditors are able to share equally when assets are available. The Bankruptcy Code has a number of provisions that assist the Chapter 7 trustee in accomplishing this goal. Under the Bankruptcy Code, a preference is a transfer of money or of an asset before the bankruptcy is filed that has the effect of paying one creditor more than that creditor would have received if the transfer had not been made. The Chapter 7 trustee has the power to avoid or reverse preferential transfers. Generally speaking, there are two types of preferences. The first type is a preference made to an ordinary creditor. An example of this would include a payment made to a credit card company. The second type of preference is a payment made to an insider. Examples of insider payments are payments made to family members or business partners. The Chapter 7 trustee has the authority to retrieve preferential payments from the parties to whom the payments were made. There is a look-back period, the period during which a trustee is entitled to receive these payments, of 90 days before the filing of the bankruptcy case for ordinary preferences, that's the preferences made to credit card companies, and 1 year look back for preferences made to insiders, such as family members. This means that if a debtor paid money to an American Express credit card within 90 days of filing, or if the debtor paid money to the debtor's mother within a year of filing, the trustee can recover this money in order to distribute it to creditors on an equal pro rata basis. When a trustee attempts to recover a preference, the trustee will often first write a letter demanding that the payee, that the person who received the money, turn the money over to the trustee. If the party who received the money does not turn over this money to the trustee will often sue the person or company to recover the money. A trustee may accept a settlement offer to avoid the time and expense of litigation. For instance, if a debtor gave the debtor's brother $5,000 to pay off a personal loan within a year of the debtor's bankruptcy filing, the trustee may settle this debt for $3,000 instead of seeking the full amount. A trustee has complete discretion regarding settlement options. Even payments made from exempt funds may be considered preferential payments. For instance, if a debtor pays a debt to his sister with money withdrawn from a 401k, the trustee is still entitled to retrieve the money, even though the trustee could not have gone after the original source of the money, the 401k. This scenario can be frustrating to the debtor, but it is the law. There is a section in the bankruptcy schedules where debtors need to disclose all preferences. And if a debtor fails to disclose preferences or tries to hide this from the trustee can be the debtor can be denied a discharge or could even face criminal charges. The public policy behind allowing the trustee to recover preferences is simple. It is not fair that one creditor gets paid something, even if the creditor is the debtor's mother, while the rest of the creditors get less or even nothing. Bankruptcy law allows the trustee to recover this money so that it can be distributed fairly to all creditors instead of just the ones the debtors really want to pay.